see you.
Amber,
Hi, Lane.
how are you today?
I'm doing wonderful. I'm so delighted to be here talking with you again today.
Me too. Hi, everyone out there, whenever you're watching this. So today, let's talk about corporations and unincorporating, shall we?
Let's do it.
Awesome. To start, what does it mean to be unincorporated?
Well, unincorporated from the Merriam-Webster dictionary means lacking corporate status or not formed into a legal corporation or not incorporated.
Seems to make sense. And then to cover the basics, what does being a legal corporation mean?
So to be incorporated is an organization formed with state governmental approval to act as an artificial person to carry on business or other activities, which can sue or be sued, and unless it is a nonprofit, can issue shares of stock to raise funds with which to start a business or increase its capital. And this is from law.com.
So when a corporation is formed, they are a artificial person, and we're going to talk more about this, but it's also legal fiction, right? So it's a fictitious entity.
Yes, that's what we're going to get into today.
Wow. So being unincorporated means that we are not formed as a corporation and that we have not asked permission to conduct our activities, right?
That is correct. And this also means that we are not contracted with the government as a business.
So let's get this straight then. We can actually have an entity without asking permission from the government.
Yes, that is correct. We can have an unincorporated business as an association, which has an EIN number. But the normal advice is from the government, the Small Business Administration would say, if you don't register your business, you could miss out on personal liability protection, legal benefits, and tax benefits. The regular advice is to complete a number of steps and procedures in order to operate legally, which includes filing with the appropriate state agencies and applying for a business license or permit.
Wow. Well, I don't know about you, and especially knowing what I know now, I think asking for permission and following all those steps didn't really give me any more protections or tax benefits. In fact, they probably put me at more of a risk now that I know what I know. Yeah. So another question then is, what's the difference between legal and lawful?
So to conduct one's business legally is conforming to or permitted by law or established rules, whereas to be lawful is that which is not forbidden by law. To be valid, a contract must be lawful, for example. So let's take a look at some history and the Constitution.
Okay.
Lane, can you read the 14th Amendment and then we'll go into some history?
Yeah, the 14th Amendment, in particular, Section 1, is pertinent to this conversation about unincorporating and corporations and who we are as people. So now there's a lot of conversation about the 14th Amendment in the private space. And some people want to correct their status and say that they are not a citizen of the United States because then they don't fall under this 14th Amendment, which is fair enough. Okay, I can absolutely see why people would want to do that. And on the other side, this 14th Amendment was created for some good reasons as well. And it was in particular to give slaves rights and freedoms and liberties that the rest of us have. And it continues to have that purpose. So all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the laws.
Lame.
Well,
So here's a little history here. The Organic Constitution was signed on September 17th. It was ratified in 1789. This Constitution, a compact with a legal fiction, the government, made the government subject to the people. In the 1860s, an unlawful Congress implemented a perverted constitution, making the people subject to government. In 1933, the governors of all 48 states were complicit with implementing this plan when they pledged all lands within their boundaries and the future labor of all people as surety for the national debt.
So looking a little further, the 14th Amendment was the first time that the government had created a lawful scenario. They ratified it into law where people were subject to the government rather than the other way around, government subject to the people. The long chain of events that led to implementing this perversion. It could only be done over time. They had to slow walk this because if people caught wind, the entire Congress would have been tried for treason.
Every natural man or woman who has a birth certificate issued, creating the legal fiction and or claims and uses an assigned social security number is a lawful representative of that legal fiction and becomes subject to government by contract. Many people have been led to believe that statutes and codes do not apply to them just because the Supreme Court clarified the fact that statutes and codes apply to government creations, such as the legal fictions, government agents, employees, and contractors, and do not apply to the natural living man or woman. What they failed to realize is that they have spent a lifetime providing documentation for government to show that they are the legal representative of the legal fiction and are subject.
So this means that we give tacit permission to these contracts to becoming a legal fiction by things such as a driver's license, voter registration, any contract for a house, schools. Those are mostly government entities. So it's a long line of not knowing that you are agreeing to be a creature of the state or a legal fiction. And this is where that conversation about not wanting to be a 14th Amendment citizen comes in as well, right?
That is correct.
Yeah. So some interesting things, and people are going to do what they want to do, and whatever's right for you and where you feel comfortable is appropriate. Okay. But some words on that, like it or not, the 14th Amendment is valid and it's here to stay. It became ratified when the states published it as law in their own law resources. It remains a benefit to leave the assertion of the 14th Amendment in our documents, since the Supreme Court has tied the 14th Amendment to the means of enforcing rights against the violation of any state government. Without the 14th Amendment wording, there would be no legal means of forcing the state governments to recognize any rights or liberties outside of their own state constitution. No one would be capable of taking their own state to federal courts to enforce constitutional compliance outside of their own state constitution. We'd have no guarantee of federal protection from federal agencies either, unless the individual states decided they are going to start doing what they're supposed to be doing in protecting life, liberty, and property of the people, even against intrusion from federal agencies. But we're not expecting they're going to be in any hurry to do what they should be doing. So as people that are in the private, with private associations, ministries, and unincorporated associations, asserting the claims of the 14th Amendment doesn't hurt you in any way, but not asserting it could be harmful. Difference between public and private law here too, isn't there?
That is correct. There are two sides. So we have our public entity, which is this corporate fiction who we have come to represent through our social security number and getting our licenses and registrations. That there's also a private side. So the public and private still provide the natural man and woman the opportunity to bring their lives into the private, affording the protections of the original Constitution and remain outside of the jurisdiction of the government. Those wanting to remain representatives of the legal fiction can do so. There are some benefits to being in the system, and bring only their business and parts of their lives into the private domain and out of the reach of government by separating their business from that of the legal fiction they represent. Keep your business within the confines of your private association and out of the realm of the legal fiction.
Wow. So you really can free yourself from the government authority and their jurisdiction, removing yourself from those rules of statutes and codes that aren't meant to apply to you anyway, right?
That is correct.
We had that whole conversation in that last video. So if you haven't seen it, go check out the founding files, our statutes, codes, rules, regulations, laws.
A legal fiction cannot interact with a natural man or woman except by contract. So, resident agent of a corporation or contracted representative of the legal fiction.
Yeah, so be careful what you do with contracts and agreements. It's one of the ways that you can bring yourself inadvertently back into the public, is with statutory language or association with corporative entities, green in contracts, forced or not. So you have to keep learning how to keep your association in the private.
Yeah, that is correct.
Cool.
Once your associations are formed, you'll still need to continue learning how to use that association for your benefit and keep that business, the business that you do therein, out of the public domain. It's easy to take your private business into the jurisdiction of the public domain if you haven't learned how to keep it private.
So keep learning, keep following this video format. I think for a lot of people these days, video format is really helpful, and look below for the content. And thank you, Amber, for a very wise and informative conversation today.
You're welcome. And I also want to give credit to and a special thanks to David Edwards and others who have helped bring this information to you here today.
Yeah, we're ever so grateful.
I know it's nothing new, but it's so good to see